Good morning. I would like to start off with a court proclamation to let you know that you are all very special and you are all very skilled. This goes back a while. In U.S. v. Prochner, the court point blank said that we're going to elevate sentences for those people who have special skills when they are committing a particular offense or crime. What was interesting about this case is they gave you examples of what a special skill was, and they noticed pilots, lawyers, demolition experts, and in Prochner they recognized computer hacking. Now, Mr. Prochner had the right to remain silent when he was arrested, but he apparently did not have the ability, because he gave a very detailed, I believe it was about a 12 to 15 page confession. So he got sentenced, and the court recognized, we're going to elevate your sentence based on this special skill, particularly since it was used to commit the crime. Well, then you go to jail, and your attorney goes to the appellate level and appeals that to the appellate level to say the district court got it wrong. We didn't have any special skills. Basically, it was he was like a script kiddie. That's all he was doing, and there were no special skills involved here. Unfortunately, they went back to that 12 to 15 page confession and said, no, the details he put in here, special skills, self-taught, and they elevated his sentence. So I start with that to let you know that you're all very special and very skilled. Clark's Law. You've heard Moore's Law, Clark's Law. Being a lawyer in this field, I find it a very exciting field. It changes very quickly. My presentation has changed in the last 3 weeks several times, thanks to many courts releasing a rash of opinions in the last 3 weeks. Your job is to explain what you do to lawyers at a third grade level. You need to do that because we need to take that information and explain it to a judge, a jury, or other people at a first grade level. So you need to bring it down and dumb it down so we can understand what you do. One of the aspects that I've always been told is facts are king. I did government contract litigation. I had a great mentor that said facts are king. So what you are doing is very fact specific, so you need to make sure your attorneys are asking you enough questions and that they understand what you do. Typically, most counsels I know, when you have a specific case, will focus on that case and ask a lot of questions and take a huge interest in it. So this is a very easy area to be interested in, but you need to make sure they're asking the right questions and the specific questions, because a passive honeypot can turn into a highly interactive eavesdropping wiretap device with just a couple changes in the facts. So you need to be specific on what you're doing. The other aspect that's very hot right now is the e-discovery rules. I'd like to say they're new, but they've been out for 6 months now. And that aspect is going to have a very large effect on what you do. Because when you're going and doing e-discovery, you can now get everything that's on someone's hard drive. Now, albeit the first thing as a lawyer I'm going to do is I'm going to say that's overburdensome, I can't turn everything over. But from that, you're talking about the metadata, and every lawyer loves to have the smoking gun. The document that just says, they knew about it, here it is, the Ford Pinto, the gas engine tank exploding, they knew about it. Everyone likes that smoking gun, and now your smoking guns are going to be found in that metadata. So you need to be able to advise attorneys on how to find it and where they should be looking for that aspect. The agenda. Like I said, when I first set up this, when you put your submissions in, you place in there what you think you're going to talk about. Thanks to the courts in this area, that has changed slightly. You're going to find when you get any kind of lawyer in this business, what they think is hot and relevant at the time is going to change. You try to keep aware of what other attorneys think is hot, and that's what I kind of try to focus on here. Active response wasn't really hot, but then I guess there's going to be a conference up in, I think it's Boston, so you guys seem interested in that all the time, so I'm going to touch on that a little bit. I wanted to try to find some cases that what the courts are really dealing with, but also something that would interest you folks as security professionals, so I thought I'd look at the aspect of liability for stolen code. Jurisdiction's been very hot for both the civil aspect and the criminal side. Web searches have been busy, and of course search and seizure has just been all over the place. And Google has been just going like gangbusters. And I don't want to say there's aspects about people saying that Google's trying to brainwash us left and right. And I'm not sure what they mean by that. Because you've got to be careful exactly what happens with those folks. But we will talk about Viacom and Google on that. This presentation, and it's interesting, I'm actually going to stay away from the NSA litigation. Not a lot has changed. They dismissed one of the cases for lack of standing, which was kind of interesting. If you want to talk about that, I'm here. Please come up. I'll be glad to talk about it. I talked about it at DEF CON last year, and I talk about it from really a law professor's point of view. I'm going to tell you what the government says. I'm going to tell you what the plaintiffs are saying and let you come to your own decision on that. So if you want to talk about that, by all means, please feel free to come up and find me, and we'll be glad to talk about that. There they are again. All right, the disclaimer. This is interactive. Please feel free to ask as many questions as you'd like. Any comments, please feel free to state them. Any good lines, by all means, throw them out. I want this to be informative, entertaining, and informative. I've been to many of the lectures so far. I love you guys and gals because you make my head hurt immediately. I have several techie mentors that they figure the job they're doing, if they're doing a good job, I have a headache in 5 minutes of talking. If they're not doing a good job, then I don't have that headache. And so getting into the details, this is one of those things where sit back, listen. You don't necessarily have to read what's up there. The material has a lot more information in there to get you diving into some of the subject matter if you have something going on. If I've missed your prosecution, I'm sorry. By all means, please stand up and share it with us. Or your investigation that's going on, those are always fun. Please stand up and tell us that you're on an investigation, and we'll be glad to discuss it. My disclaimer, I am with the government, but I'm here in my own private capacity on vacation right now. So any errors that are in this presentation remain with me, and I do not speak on behalf of any government agency. And the problem with errors is this is being recorded. I apologize for that. Hopefully, I believe I'm a lot better live and in person than on the tape. And the nice thing about making a mistake now is it's caught forever, as opposed to Congress, when they're up there speaking, they can always ask to submit extended remarks so they don't sound as stupid in history as they do standing in front of C-SPAN. So the mistakes remain with me. One more disclaimer. One aspect. When I spoke last time, I kind of gave out trinkets for awards if you participated. I'm giving away a possibility of $1 million for correct answers. Now, we're going to talk about some negligence aspects and the proximate cause and the but-for aspect. How that works is, I have these $5 Caesar's chips. So if you answer the right question and you do all the right chain of events, you can turn this into $1 million. And these are pretty cool chips. I've got a Celine Dion, Gloria Estefan, the Forums, and this Magical Empire, which the guy at the cage thought you guys would really, really like. So you can ask for that. So, one more disclaimer that lawyers always put out. Who can tell me what this means? That's naked in front of a computer. That's the wrong one. Who can tell me what this means? Come on. Oh, see, there's too many. Someone's got to stand up and shout it. They could have had a $5 chip on that one. I am not your lawyer. Again, you get 3 lawyers in a room and ask them about one case, and you will get no less than 10 different opinions on it. I've heard once that, I guess it was a comment that, liberals kind of, someone who isn't gutsy enough to take a position one way or the other and stands in the middle of the road, and we all know what happens when you stand in the middle of the road, you get run over. Lawyers can be a lot like that too. You'll argue both sides. We're trained that way. So I'm not your lawyer. I'm going to tell you what I believe the case stands for here. After I'm done, if there are any lawyers in the room, 3 of them are going to come up out of 5 and say, hey, you got that wrong. Yeah, okay, great, wonderful. So we're trying to do this, again, from an aspect of what the case means, what it stands for, and that's where we're going for on this. So let's dive in. Again, I'm Robert Clark. If you're looking for Richard Clark, you slept through that probably yesterday. I did on that, so I apologize. For those of you who don't speak English, there's my name for you. On that, I apologize. I could not put my entire presentation in code. I'll have to try to do that next year. Stuff that just doesn't fit in. Again, this when you do your agenda, recent cases come out and they just jump out at you. And this was a recent case that came out And I guess the reason it's so important is because it's the first time a case specifically said that IP addresses are exactly the same thing as telephone numbers. Now, for many years, telephone numbers under Smith versus Maryland were held to have no expectation of privacy under the theory that when you dial the phone, it goes off to the telephone company. So you can't have an expectation in a telephone number when you dial, so they can go from the telephone companies and get it and continue to do their investigation. Well, now it was specifically stated that IP addresses are exactly the same. This is an interesting aspect because, again, if I'm doing an investigation and I get the telephone number and I go and do now a Google search, I can find out that you just called Chemicals Are Us, like if it's a methamphetamine investigation and the guy's dealing with precursor chemicals. So I can find that out. But, the other aspect of it, Chemicals Are Us, yeah, if I'm doing a meth investigation, it's kind of pointing in that direction, I've got it. But, with IP addresses, I've got to admit, being a government hack, but again, trying to be, very professorial, IP addresses 10, howtokillyourmother-in-law.com. That's a little more specific than, Chemicals Are Us. Chemicals Are Us has a legitimate purpose. There seems to be some aspects on that. Now, this court did specifically talk about IP addresses versus URL addresses. It specifically says we're talking about IP addresses. We are not talking about URL addresses, which identify a particular document within the website. So they did take great pains to comment about that, but it's an interesting aspect in the case of someone finally talking about that. This case I thought you would like. This actually, Mary Jean versus the Massachusetts State Police, kind of has nothing to do with the underlying facts of the case. The underlying facts of the case are a gentleman was being arrested for a misdemeanor, and 8 armed state troopers showed up at his house, came in, was arresting him on the misdemeanor, and asked if they could search his premise with a warrantless search. The entire thing was caught on video. Now, being a father of 3, I kind of like the way this was caught on video. It was caught by a nanny cam. So it picked up everything of this guy, poor schmuck, being arrested up in Massachusetts. And he took the video and gave it to Mary Jane, who had a website, and she posted it, of course. And the state police served her with a cease and desist order, saying that it was illegally obtained and that she had to take it down. So she filed to dismiss it under a First Amendment right that there was a inherent public duty and interest in this. And to make a long story short, she won basically because the court looked at it was illegally obtained, and she said no, the guy gave it to her, but she knew where she was getting it. And there were a couple cases that were out there before that where they were anonymously dropped off that to the newspapers to publish. And the court said no, I don't care that she knew that she was getting it from the suspect in the case. This has a high interest to the public, and we're going to let her publish it and keep it up. So it was an interesting case from that aspect on the website. As I mentioned, active response wasn't really a hot topic, and then I noticed this Bob Brown article came out and this conference going on. I guess it's, did I get this right? I think it's up in Boston. And I noticed some of the names had here, some speakers are going to be speaking at it that typically speak out here. So active response is always interesting. The aspect of active response is always that theory of self-defense and self-help, which is a standard that's been around for a long time. The one we always really focus on is the trespass to chattel, how it really applies to computer cases. And the thing I always point out on this one is that the law favors prevention over post-trespass recovery. And what that simply means is, if my neighbor keeps borrowing my lawnmower, they don't like it if I go into his yard, grab it back, and ram down his gate as I'm bringing it back. It's kind of disruptive. They would more prefer that I lock it up in my shed so my neighbor can't come and get it. So again, prevention versus